You'd think the most important moments in a legal case would happen during a big, dramatic trial. But sometimes it's a single, really confusing pretrial hearing that changes everything. Today, we're going to unravel one of those moments, a hearing on December 18th that went so completely sideways, it makes you question the very rules meant to protect a person in court.
So let's just jump right into the big question here. What on earth happens when the lawyer you just hired to defend you isn't there? The lawyer you just fired is in court making huge decisions for you, and another lawyer who already quit your case because of a conflict of interest is suddenly back in the mix? I know, it sounds totally impossible, but it actually happened.
All right, here's our game plan for making sense of this legal maze. We're going to start with the puzzle of that hearing. Then we'll untangle who's who with the three attorneys. We'll dive into the ethical minefield they created, uncover a really smart strategic move, and finally reveal the powerful legal argument that just got lost in all the chaos. Okay, let's set the scene. The date is December 18th, 2023. There's a super important hearing happening, and a major decision about the defendant's plea is about to be made. But right from the get-go, the official record shows that something is very, very wrong. And this right here is the heart of the mystery. A defendant's plea gets withdrawn, which is a massive deal in any criminal case. But if you look at the official court minutes for that day, the defendant's new hand-picked lawyer, Amanda Katze, well, she isn't even listed as being there. So how could that possibly happen? The court record says the plea was withdrawn because of an or tennis motion. Now, don't let the fancy Latin throw you. All that means is that the motion was made verbally, right there on the spot, in the courtroom. This wasn't some pre-planned written thing. This was a live, in-the-moment decision. And that is the million-dollar question, isn't it? If the defendant's chosen new lawyer wasn't even in the room to make this critical oral motion, who was speaking for her? To figure that out, we have to look at who was there. So the official record shows this absolutely bizarre and ethically tangled situation. On this day, the defendant wasn't just represented by one person, but kind of by this trio of lawyers who all had completely contradictory roles. It's a mess. Okay, this is where it gets really wild. Let's break this down. First, you have Amanda Katze, the brand new lawyer, who is officially absent. Then you have Gary Schwartz, the outgoing attorney she was supposed to be replacing, who is not only there but is actively making decisions. And then, and this is the craziest part, you have Jonathan Mills, a lawyer who had already quit the case weeks before, citing a conflict of interest, but somehow he's back, present, and listed as representing the defendant. What? Now get this. This is where the problem just becomes crystal clear. The defendant had given very specific written instructions to the outgoing attorney, Gary Schwartz, telling him that absolutely no motions were to be filed without her direct go-ahead. And yet there he was, one of the two lawyers in the room who made that crucial verbal motion to withdraw her plea. This whole situation just spirals into a huge ethical problem. I mean, this wasn't just a little confusing. Looking at the court documents, it really seems like a complete breakdown of the basic rules of professional conduct, the very rules that are supposed to protect a client. So it looks like several people really overstepped. Let's start with Jonathan Mills. For an attorney to say, I have a conflict, I'm out, and then just reappear to represent that same client, that's a huge breach. Then there's Gary Schwartz making a major move while he's being replaced and going directly against his client's instructions. That arguably violates his duty of loyalty. And, you have to look at the court itself, which let this all happen and proceeded with the hearing, effectively sidelining the defendant's actual chosen counsel. It created this ethically impossible situation. I mean, think about it. The defendant was at the same exact moment being represented by the lawyer she just hired, the lawyer she just fired, and a lawyer who had already quit because he had a conflict. That's a scenario that should just never, ever happen. But hang on a second. What about Amanda Katze, the new attorney? Was she just late? Did she have a scheduling conflict? Nope, not at all. It turns out her disappearance was actually a really smart, calculated legal move. Literally just minutes before court started for the day, at 8:54 in the morning, Katze filed an official document called a Notice of Unavailability. This wasn't her asking for a new date. This was her formally telling the court, on the record, that she would not and could not participate in whatever was about to happen. And this was a genius move for three big reasons. First, it created a permanent, undeniable record that she wanted no part of this flawed hearing. Second, it put distance between her and her client. and the ethically questionable actions of the other lawyers. And third, and this is so important, it preserved her client's right to appeal any decision made that day by arguing it was totally invalid because her chosen conflict-free lawyer wasn't involved. So after that chaotic hearing, you'd think things would get back on track. Attorney Kazi started working on what should have been the next decisive step, a really powerful motion that went right at the heart of the state's case. But in one last confusing twist, this brilliant piece of legal work just vanished. What she did was draft a motion to dismiss the most serious charge the defendant was facing, a first-degree felony. And this wasn't some nitpicky argument. It was a direct challenge saying, hey, this charge is legally impossible based on the state's own evidence. And her argument was devastatingly simple. Check this out. The law for that specific felony requires a successful fraud where someone actually gets a benefit of over $50,000. But the state's own charging documents admitted that the fraud was only attempted. It was stopped. No money, no property ever changed hands. The charge just didn't fit the facts presented by the prosecution itself. But then the whole strategy just completely collapsed. Look at this timeline. In late December, Kazi drafts this killer motion. By January 18th, she's off the case, and that motion never filed. Then, in a truly shocking turn, Gary Schwartz, the guy who was just replaced, gets reappointed to the case, and by February 12th, a trial is scheduled with that legally questionable felony charge still hanging over the defendant's head. Let's just focus on that number for a second. The amount of money or benefit that was actually received, according to the state's own evidence, 0. A big fat 0. And yet, the charge, which carries a mandatory minimum prison sentence, was still in play. The one motion designed to fix this was just gone. So, a moment of real legal clarity, a powerful logical argument that could have changed the entire trajectory of the case, was just erased. The procedural mess on December 18th ended up leading to a strategic dead end, and the defendant was right back where she started, only now with even less time and fewer good options. And all of this leaves us with a really fundamental question. The right to choose your own lawyer is supposed to be a pillar of our justice system. But when the procedures in a courtroom get so confused, so tangled up in conflicts that your chosen lawyer is basically pushed to the side, what's left to actually protect that right? It's a puzzle that goes way beyond this one case on one chaotic day in December.